violated a right to receive information. And if the information doesn't come forth, that right has been violated, and therefore there's an injury. Now, in this case, Congress has just said a third party can ask the Patent Office to do something, which you have and which they have. But beyond that, you have no right to receive any particular outcome, do you?
I believe we do, Your Honor. We have a right to receive an outcome with which we are satisfied.
No, the burden is on the Patent Office to either find it's patentable or not, that it's eligible or not. That's not your interest at all.
Well, I would disagree, Your Honor, because
okay,
I would compare...
Help me out.
I would compare this scenario to the ex parte reexamination scenario, where Congress did not create the right of third parties to continue to participate, did not create the right of third parties to appeal, said you're allowed to request it, you're allowed to respond to an initial response if the patentee makes one, but after that, no longer can the third party have any right to participate at the Patent Office or the courts. And that's what this court found in Boeing and Syntex. In both cases, this court said it's because there isn't a statutory right to continue to participate and then appeal that there's no standing there. That's exactly right after those cases is when Congress passed the inter partes reexamination rules that we exist under, although now they've been...
You said earlier, I think in response to Judge Hughes, that you were the only people that could bring this. Did you say that?
We could only... Yes, Your Honor. We are the only party that could bring this appeal in this court. We're the only we're the only party who could have Article III standing to bring this dispute to this court. No one else could, because we are the only party who requested this inter partes reexamination. No other...
because you requested it, but not necessarily because you're the only people that would have what you consider as...
Same in FOIA, same in Aikens. Anybody can request information from the government, but only the party who's requested it then has standing to an appeal an unsatisfactory response.
Justice Kennedy, in his concurrence in Lujan, which was repeated by the majority in Massachusetts versus EPA, he said that, in his view, Congress has the power to find injuries and articulate chains of causation, even where none existed before. Now, that's the part that Consumer Watchdog cites, but I want you to hear the rest of it because it's important. And what it says, in exercising this power, however, Congress must, at the very least, identify the injury it seeks to vindicate and relate the injury to the class of persons entitled to bring suit. And then he goes on and says, still, the party bringing suit must show that the action injures him in a concrete and personal way. I just think it's extremely difficult in any of these cases for Congress to override Article III standing. The party still has to show...
Well, how was that shown in the Adkin case? That's the FEC case.
The Adkin case, they actually didn't rely on the statute to find an injury in fact. They said that the statute shows that there's procedural standing, but they went on and said there's an injury in fact because this particular voter, had they known of the information, would have been able to vote with more knowledge. So there was an actual finding of injury in fact in that case. I know Consumer Watchdog's brief says otherwise, but if you read the case, it actually does find that there's an injury.